So we got some stuff to get into because, bruh, what the hell? The feds decided to respond, then the judge responded, then turn around, Drew already on their heels like, y'all can't even do this until something else happened. Don't worry, we're going to get to the particulars right about. So here we go right here, United States versus Durk Banks and everybody else. Proposed order. For good cause shown, it is hereby ordered that the government's Exhibit 1 through 6 in opposition to defendant Banks' motion to dismiss for vagueness or, in the alternative, for a bill of particulars shall be kept under seal until further order of the court. In case of denial, the government's ex parte application for order sealing document is denied. Underlining documents shall be returned to the government without filing of documents or reflection of the name, of nature of the documents on the clerk's public docket. So the feds are basically saying, yeah, we got something for you, bro. Like we have it for you. We just want it to be under seal. Like, Judge, your eyes only. Only you can see this stuff, and that's what it's gonna be. Drew has basically said, nah, bro, we gotta see this. So the judge is saying, for now, we're gonna let this stay, and I'll rule on it on a later day. But I ain't gonna lie, they might not be sleeping over there. I think Drew might only be eating, showering, and reading books. Marissa, reading, showering, and in books, and that's it, bro. Because at the end of the day, bro, they're firing back quick as hell. They told the judge, hey, homie, you can't say nothing. Don't worry. Roll it. Drew Finland, Marissa Goldberg, United States District Court, Central Florida, United States Plaintiff versus Durk Banks. Defendant's joint objection to court's November 14, 2025 scheduling notice and order, meaning they trying to hit the pause button. Let's get to it. Introduction. As Justice, I don't know how to say none of this, Brandeis, we just going to say Justice B observed, sunlight is said to be the best of disinfectants. Defendants object to court's November 14, 2025 order docket 291, scheduling a closed-door status conference on defendant's joint motion to disqualify, dismiss indictment, vacate schedule order, reopen pretrial hearings, and hold an evidentiary hearing based on 5th and 6th Amendment violations docket 290, defendant's joint motion, and maintaining the hearing on substantive motions set on November 18, 2025. The order violates defendant's Sixth Amendment right to a public trial and improperly permits substantive litigation, while a recusal/disqualification motion directed at the entire Central District of California bench and United States Attorney Office for the Central District, USAO CDCA, remains pending to the extent that the court's decision to close the hearing is to avoid disclosing the nature of the threats in the rest of the bench. This concern only reinforces the need to transfer the recusal motion outside of the Central District. Further, the court must defer any substantive rulings, including pretrial motions, until defendant's joint motion is resolved. So y'all remember when YNW Melly got his case pushed back basically to 2028, or really 2027? This is one of the things what it looks like when they're trying to get that done. Accordingly, defendants request that the court vacate the closure conduct proceedings in open court and stay substantive proceedings pending resolution of defendant's joint motion by another judge, specifically an out-of-district judge. Factual background. On November 13, 2025, defendants filed defendant's joint motion, docket 290, alleging the prosecution team concealed for over 7 months death threats made against Magistrate Judge Patricia Donahue, Assisted United States Attorney Ian Yanello, and Courthouse USAO personnel. Defendant's joint motion argues that these circumstances created an appearance of partiality under 28 U.S.C. 455A and violated defendant's constitutional rights under 5th and 6th Amendments. It requests judicial recusal/disqualification of the USAO CDCA, dismissal of second superseding indictment, vacatur of the scheduling order, docket 2206, reopening pretrial hearings and reassignment to an out-of-district, out-of-circuit judge. On November 14, 2025, the court issued the following scheduling notice and order. The previously calendared motions will be heard as scheduled on November 18, 2025, 10 a.m. The court will hold a brief status conference with the courtroom closed in regard to the newly filed motion argument. The court's order to conduct a closed-door hearing violates defendant's Sixth Amendment right to a public trial. The Sixth Amendment guarantees in all criminal prosecutions the accused shall enjoy the right to a speedy and public trial. The Supreme Court has reaffirmed the public trial right not only for the trial itself, but to all critical pretrial proceedings. The public trial right attaches to those hearings whose subject matter involves the values that the right to a public trial serves United States versus Waters. Those four values are: 1, to ensure a fair trial; 2, to remind the prosecutor and judge their responsibility to the accused; 3, to encourage witnesses to come forward; and 4, to discourage perjury. Applying the standard, the Ninth Circuit has reaffirmed the defendant's public trial right in a myriad of contexts, including proceedings before, during, and after trial. See Waters. Concluding that Waters' Sixth Amendment public trial rights attached to her pretrial hearing, we hold that the district court erred by closing the hearing to the public. United States versus Rivera. We hold that the Sixth Amendment right to a public trial attaches as sentencing proceedings. United States versus Ramirez. Finding district court plainly erred in making only a written finding of guilt following a bench trial, rather than announcing its finding in a public setting. Before ordering total closure, the court must determine that there is an overriding interest based on findings that closure is essential to preserve higher values. United States versus Allen. It is difficult to imagine a proceeding that more directly implicates the fundamental principles of a defendant's public trial right than a motion seeking the recusal of both the bench and the prosecution. Deciding any part of such a disqualification motion in secret would undermine the central purpose of the public trial guarantee. To remind the prosecutor and judge of their responsibility to the accused, defendant's joint motion does more than allege bias by the USAO, CDCA, or the court. It asserts that critical facts were withheld from them as they litigated their defense, leaving them unaware of significant events occurring behind the scenes. The court's order directing the closed hearing on defendant's joint motion violates their Sixth Amendment right to a public trial. There is no overriding interest justifying closure of this critical proceeding. If any interest exists that might warrant limited restrictions, it would only reinforce the need to refer the matter outside the district rather than potentially deny defendant's motion summary at a brief status conference. The court should not proceed on substantive motions while defendant's joint motion to disqualify remains pending. Federal law requires recusal/disqualification in any proceeding in which the court's impartiality might be reasonably questioned. So remember when Weinstein came up to Glanville and was like, "Judge, you don't want to recuse yourself after this, bro? You kind of making the court look bad." And Glanville like, "No, motion denied. So it always goes to the judge to deny the recusal, which is pretty damn dumb in my opinion. But it's the same exact thing that got Glanville thrown up off the bench almost. Because depending on how the judge rules, whatever wording they use and all of this crap, that's what's going to get him thrown off the bench. So remember, y'all remember the ex parte meetings with Woody and Caleb Bumpus and all them and everything. What got Glanville thrown off was the way that he handled it. So there's precedent for this at, in local Georgia court, but we're going to see how this basically goes out. This objective standard turns not on whether or not the judge actually knew of the facts, creating an appearance of impropriety, so as long as the public might reasonably believe that he or she knew. Recusal is mandated where a reasonable third-party observer will perceive that there is a significant risk that a judge will be influenced by the threat and resolve the case on a basis other than the merits. Meaning, you can't go off of feelings, you just go straight off of facts, bro. Recusal required when the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. Defendant's joint motion raises substantial allegations. Judge Donahue received explicit death threats referencing defendants that threatened her life and the lives of all courthouse personnel. This court knew of those death threats as of February 25, 2025. The prosecution team then engaged in ex parte communications with the bench and actively participated in criminal investigations where a judge presiding over this case was the recipient and intended target and victim of those death threats. The prosecution team continued to press forward with litigation in front of Judge Donahue, who then presided over detention proceedings while threats to her life were under criminal investigation by the prosecution team. This court adopted her findings without disclosing the death threats, and the prosecution team concealed those threats for over 7 months until they wanted to use them against defendants in seeking an anonymous jury. See, yeah, that's a big-ass problem. These allegations create a serious risk that rulings may be perceived to have been influenced by factors other than the merits. Whether these allegations ultimately warrant recusal/disqualification must be decided by an independent arbiter. In the interim, the court should not make substantive rulings until the joint recusal/disqualification motion is resolved. Court recognized that challenged judges should await resolution of other aspects of the litigation while the recusal motion is pending. Only after the legal sufficiency of this affidavit is determined does it become the duty of the judge to proceed no further in this case, quoting United States versus Monteclavo. And then we go down, given that disqualification disputes concern the basic integrity of a tribunal, they must be resolved at the outset of litigation. Stressing courts should defer substantive rulings until the recusal motion is resolved. These issues concerning the propriety of the action of the district judge in adjudicating the disqualification motion logically precede the adjudication of the case on the merits. Following the filing of a motion to disqualify a magistrate judge, such judge shall not proceed with the matter until the motion has been determined. Proceeding, notwithstanding the recusal motion, would create an appearance of impropriety that cannot be remedied later. If the disqualification motion is granted, any intervening rulings will have been made by a judge who should have been recused. If denied, defendants will perceive the court ruled against them, while the challenge to the court's impartiality was pending. Either outcome undermines confidence in the fairness of these proceedings. Further, it would be a waste of judicial resources if the court's substantive rulings are later set aside. Vacating substantive orders upon discovery of conflict that existed at the time of the judicial officer issued orders. Conclusion. Defendants respectfully request that the court conduct all proceedings on defendant's joint motion, docket 290, in an open court. Stay all proceedings in this case, including the pending substantive pretrial motions, and refer the recusal/disqualification motion to the chief judge for assignment to an out-of-district judge.
So Drew and them are essentially saying, yo, judge, you can't even rule on this. You can't rule on this because we already had something against you. And the feds are funny because they're trying to do the whole entire, we're not going to drop y'all any major stuff until basically 10 days before or right before they hit the stand type stuff and then on your recross. So I'm curious as to who's going to be in the start lineup. You know, one of the things that a lot of these lawyers do, and y'all see them writing down all the time, they're writing down what they need to say at cross to cross them up, to trip them up, if you will. Not in a negative way, of course, but sitting up there saying, yeah, this person lying, this person lying, this person lying. So there's always these things where you can depose somebody, you know, and you can ask them certain questions and talk to them and all that stuff and build up whatever from whatever theories and all this crap. But as it stands right now, bruh, they got a battle on their hands because the judge is the one who ultimately is going to say, good to go, not good to go, good to go, not good to go. And I believe the feds are lying. I don't care. I believe the feds are 100% lying because at the end of the day, you can't say, oh, this, and that, meaning these freaking threats are real. Then we evaluate them and nah, they're actually not real. But also use that to withhold bail. You use that to basically tell a freaking judge we need to impanel a anonymous jury. Like, you're using stuff, but you literally just said out your mouth, oh, well, these ain't really threats. These is actual fans, bro. So we don't blah, 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 and all this stuff. We don't really care. Like, we're still going to do this because what are you saving them from? Because there's no threats. The only threat is of what? Harassment? That's the only threat of harassment. But they're using this BS from quote unquote feds. How do we know that the feds ain't do this? Now, there was somebody who put in the comment section and it was a very, very valid point. So I don't want to sit there and be like, yeah, nah, I just skipped over this one. When y'all make valid points, bro, I will bring it up and do my best to address it, whether I agree or disagree. You'll know when I address it. But dude basically said, or as a woman, I don't remember, but I just remember the comment. They said, yo, Ceddy Nash, how do we know that this ain't just something that they use, the feds, meaning how the feds use it to basically make the jurors scared? Somebody else also wrote, bro, how do we know that rappers ain't looking at this like next time we go to the feds, bro, we're going to go ahead and have our fans call in and all this shit and everything like that. To the second point, not going to happen. If you are dumb enough to give instructions to basically disrupt the whole entire case, you lost. You lost. There's no winning when people are doing certain things like that. If you want to decide, oh, I'm going to mess my whole entire case up by sitting in the feds like, give a call, y'all. You know what I mean? If you think you couldn't put up a bat signal for fans to basically say, we're going to call district judges and DAs and all this stuff and everything, bro, these are fans. They're not, ain't no hood dudes doing this shit. These are suburban kids or these are just youngins. They just fans of you, bro. Go to these rap shows. Very mixed, blended crowds. You think they going to hold it down? You think they ain't going to sit up there and go, I'm facing 10, 30, 40 years just for a phone call that the rapper told me to do? Nothing happens if it's the feds. I like to see, if I'm Drew, I'm thinking to myself this, I want to see how thorough this investigation was. How do we know this even happened? Number one. Two, how do we know that y'all really vetted this? And three, what was the determining factors for you to say, I vetted all of this stuff? And four, when the hell was you going to tell me? Because you should have kept me in the loop about this way before. Because now it does look bad. I don't like, even if Drew is on some bullshit, it doesn't matter because the feds are making it seem like this is such a damn threat when in all actuality, it wasn't. So it should have never got that far. And y'all definitely should have never used this shit in court. Y'all use this and you guys are using lyrics from a song from freaking 7 months prior. You're talking about a DJ Academics interview where you clipped it. For the youngest, that's clip farming. And you didn't even tell the whole entire truth. I hate rats. All rats, I hate them all. If you're a rat, I effing hate you because you took my dad away from me. A snitch got my dad thrown in prison for this much time. You don't think? Y'all ever met one of them weird kids who doesn't like a figure or something like that based off of something that figure might have did or might have said, and they might even be a good person? It's the same shit, bro. The same shit. There are people who hate Santa Claus right now because Santa Claus never dropped no Christmas presents underneath their tree. You got people who don't like certain people because of what didn't happen for them specifically. So what are we doing here? You being mad at people or a person who feels as though their father was an innocent individual who a snitch is the reason why he got thrown in federal penitentiary for over 20 years. If you don't feel that way, something is wrong with you. So yeah, bro, listen. Subscribe, turn that bell to notified, share to keep your people at work. Click right here and see how somebody was snapping photos of Whack 100 in LAX and said, be on the lookout. Or click right here for the playlist, man. If y'all can, hit that like button like you like something. Let me know your thoughts. Xbox, PlayStation giveaway still going on, man. I appreciate you all for real, man. Vacation is over. We be back home tomorrow. I'll catch y'all in the next one.